The challenge is, or I would argue that a lot of people are not really being compliant on the 506B scenario. I mean, do you really have pre-existing substantive relationship with your entire list? I mean, think about your own list. I mean, if I went into your list and plucked out a random prospective investor that you met at some event, do you have a questionnaire for them? Have you had a couple of phone calls with you? Have you been able to identify and gone through the process of establishing that substantive relationship with every single person on that list? There's an argument to be had that you haven't, and I think the people who argue in favor of 506C, that's one of the main arguments, is that it's challenging to be perfectly compliant with a 506B. Welcome back to episode 18 of the Real Estate Syndicator Live. Super excited to be back. Hopefully you guys enjoyed Brandon Turner last week. If you haven't, it should be on the Facebook group. I highly recommend you check it out. Just a lot of cool conversation, a lot of great feedback from that episode. So today we're going to talk about Reg A. Been getting a lot of, the reason this came up is because we're getting a lot of questions about Reg A, and I think it makes sense considering that I'm seeing more and more of a transition or a move toward doing funds. I think people are there's some money out there, people want to get it. And so a lot of people are doing funds, and Reg A starts to make a little bit of sense when you're doing funds. It doesn't really work, as we'll talk about in a second, when you're doing a project specific deal. But if you're in the business of doing a big fund or, a fund of funds, or you're kind of, running out of, your options with the 506B, then this is definitely something at least to consider. Full disclosure, I'm always looking to figure out how I can add as much value as possible. We don't even do Reg A's at the firm. So I'm not here to push you in any particular direction. I just want you guys to know there's an option out there, and we can always put you in contact with the right people if you're thinking or think it's a good option for you. But we actually don't do Reg A's for a variety of different reasons, which I'm happy to talk about. But one of the reasons really to discuss it is, most people, I think the vast majority of our clients still use 506B in general. And the reason for that, I'm guessing, or I think is pretty obvious, is people want to have non-accredited investors in their deals. So that's really the allure of a 506B deal. The challenge is, or I would argue that, a lot of people are not really being compliant on the 506B scenario. I mean, do you really have pre-existing substantive relationship with your entire list? I mean, think about your own list. I mean, if I went into your list and plucked out a random prospective investor that you met at some event, do you have a questionnaire for them? Have you had a couple of phone calls with you? Have you been able to identify and gone through the process of establishing that substantive relationship with every single person on that list? There's an argument to be had that you haven't, and I think the people who argue in favor of 506C, that's one of the main arguments, is that it's challenging to be perfectly compliant with a 506B. And so Reg A starts to become interesting because with the Reg A, as you probably know, you can have sort of your cake and eat it too, at least on the surface, which is you can advertise your deal, but you can also accept, I don't say an unlimited amount of non-accredited, but there's really, there is a limitation. I shouldn't say there isn't. There's actually a 500 limitation, but essentially it's not really an issue when you're doing with the non-accredited. And this really has become a better option for people since the rule was updated. The rule was updated in 2015, so it's been about 7 years. And up until 2015, nobody used Reg A. It made no sense because, number one, you were limited to only, I think it was $5 million raise on Reg A before 2015 update. And most importantly, it didn't preempt state law. That's the big reason why nobody used it. As you guys know from our talks, preemption is a big deal. And that's why people use 506B and 506C, because once you comply at the federal level, I don't have to worry about all the states. I don't have to go hire an attorney in every single state. I'm pretty much assured of compliance. As you guys know, the nightmare it would be to try and make sure that your deal, it fits into every single state that's out there. So prior to 2015, honestly, I think there were like 5 or 6 or 10 Reg A deals that being done. But then in 2015, what happened was they actually introduced what we now call affectionately Reg A plus. But realistically, Reg A plus is just sort of the second tier of Reg A. They basically divvied up Reg A with the old Reg A, which is what tier 1 is now. And then they introduced this new tier 2 Reg A, which now we call Reg A plus. And the big deciding factor on that one was the preemption. And that was a last second addition to the rule. And so Reg A plus or tier 2, the main benefit is that it preempts state law, which is why now more and more people are using it. But let's just go through, and I see some people already in the chat here. Let me just make sure I can see the chat. If you guys have questions about this topic, hey, Nathan, Taylor, just drop a question in the comments and we'll get through them. But let's go through the pros and cons. The first pro, I mean, the first pro is the preemption. So that's a key. So, and again, I'm sorry, let me just backtrack. I'm not going to talk about tier one. Nobody uses, I mean, I don't know why you would do a tier one, sort of a regular Reg A. We're only going to talk about Reg A plus, which is the one that has the preemption and the one that people are using. And so that's kind of one of the big pros, is that we finally have a preemption of state law. So I don't have to go hire an attorney in every single state like so many of the other exemptions, and one of the main reasons nobody used it. So that's kind of one of the big pros. The other pro is they've increased the amount that you can raise significantly to not unlimited, but it's now up to 75 million. They just updated that actually a year ago. It used to be 50 million, and now it's $75 million in any 12-month period, which for most of us, that's not quite unlimited, but we don't have too many clients that are raising more than $75 million. And so that's a good thing. The main benefit, obviously, is that you're able to both advertise your syndication, just like a 506C, but you could also take, again, almost unlimited non-accredited investors. When I say non-unlimited, we still have limitations. At some point, you've got to go public. So you're always limited to 2,000 investors in general. If you have 2,001 investors, you're going to have to register your company as a public company. But on the non-accredited, you're going to be limited to 500. But again, how many of us are going to have anywhere near that number? And so for all intents and purposes, you don't have to worry too much about the limitations of non-accredited. In terms of the amount, now you can't take any and every non-accredited investors. You are going to be limited to taking 10% or up to 10% of their net worth or income, whichever's highest. So that's the main limitation on the non-accredited. You can take up to 500 non-accrediteds, but you're only going to be allowed to take up to 10% of their net worth or income in terms of the amount of money that they can invest in any 12-month period. So not a huge deal, I think. Unlike, what's the other one? Unlike the regulated crowdfunding, which maybe we'll talk about that some other time, where it's the lowest of the 10% of 10% net worth or income, whichever is lowest. With the Reg A, it's whichever's highest. And so if somebody's making a lot of income or has $600,000, $700,000 net worth, then they're not accredited, but you can take 70 grand, which is a good number. The other interesting thing about Reg A plus, which I think will tie neatly when we get to the point, we'll talk about maybe some resales and tokenization of the stuff. There's no restriction. It's not a restricted security. Most people forget when you're doing a 506B or a 506C, you're actually issuing restricted securities, which means you basically cannot sell those securities for 12 months. There's like a 12-month holding period. So you can't just buy a deal from a 506B and then 3 months later turn around and sell it. If you can find a buyer, you're restricted to that. But with a Reg A plus, you don't have that restriction. So from a resale perspective, and if we ever get to that point where things are tokenized and things are on exchanges, you're going to be able to actually purchase a Reg A offering and then turn around and resell it without any of that, without having to worry about the 1 year withholding. And then but we have the kind of testing the waters option on a Reg A, which if you're not quite sure if you want to do a Reg A, if you're going to do a 506B, 506C, you can actually go out there into the public social media, into the public domain, and kind of gauge interest. Just, hey, I'm thinking about raising money. If somebody's interested in that, give me an interest form. It's non-binding, but at least give me an idea of what kind of demand there is for my product. And you're allowed to test the waters prior to actually going through the whole process of doing the Reg A process, which is really the main negative of a Reg A. So we'll hop over to the cons, but it all sounds great. I always joke that's like, hey, Mauricio, this is great. You never talk about Reg A, but I can advertise and I can take non-accredited investors. Why don't we all do this? And it has to do with all the cons, right? As most of you, I think, know, the big con is that you have to register it, right? It's a mini registration. It's not like going public. It's not a full-blown registration with the SEC. But unlike 506B, unlike 506C, we actually have to present all of our offering docs, the PPM. There's an offering statement that we prepare, submit it to the SEC, and we actually have to get that approved. And so that's a timely process. It takes about, what you'll probably hear most of the time is about 6 months process from the time that you actually submit the documentation to the SEC. And the reason for that is quite simple, is that when you submit it to the SEC, there's going to be an attorney, a securities attorney representing the SEC that's going to be assigned to your case, and they're going to go through that give you comments and tell you what they don't like about your docs, and some risk disclosures that you forgot to put in, or whatever it is that they're going to come back and forth. And you're literally going back and forth with the attorneys, and that just takes a while. As we all know, the government isn't exactly the fastest, the most efficient agencies around. And so that process of going back and negotiating basically with the attorneys, every time they give you feedback, it takes you time to then resubmit another draft, and then they're going to sit on it for 30 days or whatever and give you more comments, and you end up going through numerous rounds of comments. And that process just tends to take 6 months. It can take less. It can also take more. Probably the most well-known cases, Grant Cardone tends to do a lot of Reg A's because of his social media presence, and because I think of his celebrity status, it just ended up being a lot longer than, not a lot longer, but maybe closer to 9 months and 6 months. But it just takes a while, which really then limits you, and that's why I started the conversation, where it really limits you to funds. Because if you obviously are in contract and you've got to close on a building, and you've got 90 days to close or 120 days, you don't have time to go do all this nonsense of going through the SEC. And so it doesn't really work for project specific. But if you're doing a fund and you've got really no deadline, you don't have a property that you've got to close, and you can wait 6 months or 9 months, let's call it 6 or 9 months, then it's something that you can consider, because you don't have a deadline. So that's why it really works primarily for funds, and obviously fund of funds, which is a form of fund. The other negative is, because you're having to submit it to the SEC, because you have to get the negotiations back and forth, the cost is, I don't say astronomical, but it's significantly higher than a regular 506B, 506C. You're probably looking at something in the vicinity of $70,000, $80,000 in legal fees just to get that thing going. And then you've got all the ongoing compliance, which usually the attorneys that prepared everything is going to do for you. So you kind of have an annualized ongoing fee. So again, you can see why back in the old days, when you could only raise $5 million, that started to not make too much sense either. But now that it's 75, most people that do a Reg A will typically max it out. So until recently, the only one that we've really done, which has been about a couple of years ago, the limit was only 50 million. But again, we would do a $50 million max because we want to max it out. We want to get the most bang for our bucks. And it's not just the back and forth of the attorney, the discussion with the attorneys, but the other cons that you have is that you have all these reports, not too unsimilar of public companies, those quarterly reports, the K1s, not the K1s, the Q1s, that the 10Q statements that the public companies have to do. We have to do the same things. We have annual reports, semi-annual reports, entry reports, every time there's a material change report. I mean, there's like reports up the wazoo, audited financials. I mean, there's all this compliance nonsense, which again, to me, just equates to cost. So in addition to all the attorney fees and everything that you're paying your securities attorney to negotiate, not only prepare the docs, negotiate with the attorneys, but then you've got to do all the compliance, including the audited financials. And those are kind of a pain too, because you have to get $0 audited financials. So like if you're doing a brand new fund, right, just like in a 506B, 506C, it's a brand new company. There's no financials, let alone audited financials. But with the Reg A, you literally have to go hire a company to put a bunch of zeros in your balance sheet and in your, and in your P&L. And those aren't cheap. I mean, the cheapest one I found, you're still going to end up spending, 5, 10, 15 grand to do these zero balance audited financials. So that's kind of another pain in the butt. But at the end of the day, the main con is really the time and the expense. But if you can stomach that and you've got time to wait, there's something to be said to be able to then, be able to go on podcasts and go on social media and basically do what you would do under a 506C, but also accept, non-accredited, which I think is a big deal, especially these days with social media and everything. If you've got a big following, if you've got a podcast, if you've got, an audience to launch, it kind of expands your horizon. So anyway, I thought that was an interesting comment. I do want to, and I'm going to put him on the spot here, Kevin. I know you're on here because I saw you pop in there. But if you've done a Reg A, I think it would be fun, and it would be helpful for the community to kind of get your thoughts from the, not from the legal. I know what the perspective looks from our perspective, which is kind of a pain for us to draft the docs and negotiate.
Right.
But we've got to do a legal opinion, which that's one of the main reasons firms like us that don't want to do it. We just don't want to, legal opinion is a legal opinion. And that's part of the reason that also incurs quite a bit of cost. But I know that Kevin, you're on here, and I know you reached out on the Facebook community and was kind enough to share that you've done a Reg A and you've got a lot of lessons and stuff. And I would love for you to share with us the good and the bad of your experience going through a Reg A.
Yeah. Can you hear me, Mauricio?
Yeah, you sound great. You sound like a pro.
Yeah, sorry, I got a little bit of a frog in my throat. Yeah, so Eric Upchurch and I think he's on the call as well.
Yeah,
from ADPI Capital. So obviously part of the active duty passive income community. This is our Reg A component, private equity firm that we've recently launched. So to give you guys an idea, we are in week 6, maybe week 7 of Test the Waters. So we're in that phase now where we're going back and forth with the SEC, but some things, so all of those cons that you said were spot on. Some other things that we're learning now, just based on the climate of, so when you do a Reg A, I totally agree, Mauricio. If you don't have a community behind you already, you're going to fight an uphill battle big time. But because we have 56,000 real estate investors in our community, it's really easy for us to just go and, like you said, go on the podcast, do this, promote, blah, blah, blah. But also note that every single bit of promotion that you do, from a podcast script to a video to a social media post to an email, has to be recorded and submitted to the SEC. Every single thing. So we have a whole system in place. Like, and Eric, I think I've chastised Eric before about sending out posts and be like, dude, you can't do that. You got to put the disclaimer on it. You got to do that. You got to do that and take it down.
No, I'm glad you brought that up.
Not even a short disclaimer, a long disclaimer.
Yes, a big old disclaimer. So that was something that, like, I've heard, I've educated myself on the process beforehand, obviously, and I was like, oh, test the waters. Yeah, we'll turn in our stuff, but they want every single thing.
Yeah.
So,
and one other comment on that, because we've had that the ones that we've done, we've had that issue too, where the attorneys will actually look up your website. Like, unlike obviously with the 506B, nobody's looking at it, but in this case, they'll actually Google around, they'll look at websites, and then they'll pick it apart, and they'll literally, as part of that negotiation process, they'll say, hey, look, first of all, they'll ask you, what is all this stuff that's on your website? You didn't mention any of this in your offering docs. Give us some more feedback on that. And then, to the extent you don't have the proper disclaimers on the website or whatever. But just to be fair, Kevin, too, and I've talked about this before as well, that again, we don't have the SEC looking over our shoulders at that point. But even if you're doing a 506B, just think about that. Every time you're doing a webinar, most of us do webinars. That webinar, even though it's an oral webinar, I always tell people to think about it as like, just pretend you're transcribing the webinar, and then you're just attaching it to your PPM, because everything that comes out of your mouth, whether it's in a website, whether it's in a webinar or a social media post or anything, that's part of your oral disclosures, and those need to be complete as well, which is why attorneys get a little bit nervous when people go off and do these webinars and everything without having counsel look at it, because that is technically part of your offering. And the difference with the Reg A, again, is that you have an attorney that's actually on the other side really looking at it. So, but great. Those are great. Any other thoughts there, Kevin?
A lot. So what the challenge we're currently facing is the reviewer at the SEC, and this is obviously an anecdote, right? You don't know who you're going to get when it's like, what's a box of chocolates, right?
Yep.
Forrest Gump.
Yep.
Yeah. So you never know what you're going to get. And our reviewer picked our thing apart. We had a Form 1A. We went with crowdfunding lawyers, and I know, Mauricio, you don't do it, and I'm, whatever. Like, we went with the same people that Grant Cardone went with. We shoveled a bunch of money into the project, and that's fine. That's part of the gig. But our reviewer picked it apart, and honestly, like, our attorney went to all of her peers in the Reg A space and was like, this thing that the reviewer is saying isn't even right. Like, it's not even proper. But there's nothing we can do about it, because they're the SEC, like, they're the gatekeepers, right? So you got to kind of, you're playing their game, so you got to kind of play their game, right? So we had to go back, redo our pitch deck, take a lot of things out of it that was, quote unquote, highly promotional. So things that you would, see in a 506C, or, think about a 506C pitch deck that I'm sure everyone on here has read. It's like, preferred return and this and that. You can't do any of that on a Reg A. You can't. Our reviewer didn't like it. Let me put it. We can't.
No, and it's true. And that's some of the feedback, because which actually starts to make sense. You're doing a fund, obviously. And so Grant Cardone had the same issue, which is Grant Cardone wanted to say that you were going to get a projected 15% IRR, and you're going to 3x your money. but the SEC came back and said, you don't have anything in your fund. You have an empty fund. How can you say you're going to get these projections when you don't have anything in your fund? And so those are great examples of like, you want to put this return, then they'll come back and say, you got to take that out. And I think where Grant got into trouble is that he said it anyway on social media posts and all that stuff.
Yeah. So we had to pull those social media posts, in our test the waters, which is why you do test the waters, right? Like they'll slap your wrist and you can pull it away. And as long as you don't keep poking the bear, you'll be fine. And we had to change our pitch deck and what we put out there. And that's going up for comments this week again. The other challenge that we're recently facing is even though it's a Reg A plus tier 2 and it's state exempt, you still need to notify all of the states that you are doing this. And in my, like when I was first doing this, I was like, oh no, it's state exempt. It's just like a 506C. We're just no, it's not like that. So what we've realized is there's 4 trouble states, Washington State, New Jersey, Florida, and Texas.
Not Wisconsin? Wisconsin's not on that list?
No, Wisconsin is not on that list.
Yeah, okay, good.
These 4 states, New Jersey's not so bad and Washington's not so bad, but Florida and Texas specifically, like we just are. So it's a whole nother, it's not our SEC attorney that is doing this compliance for us. We have a whole nother team of compliance attorneys, and they just came back literally yesterday and said, we can't, like they went to a Reg A conference that was that last weekend, and they said, we cannot do these states. It will take too long. The backup in Florida, and this is another story I'll tell you guys, Grant Cardone, the only reason he got his Reg A approved in Florida was because he called the governor's office. So I don't know Ron DeSantis personally. Right. I'm sure Grant does.
I'll call
yeah.
him.
Okay, Eric. Yeah. Why don't you make that phone call for me? When you're done, call Biden and yeah. But the point is that the states are so backed up, like from what we've heard from our attorneys and like what's kind of going on in the Reg A sphere is that in Florida, there is one state person who apparently is quite old, who is responsible for all of the like stamping of approval and reviewing these in the state. And that person is like on COVID protocol and hasn't been going to work. And it's just like that side of the government is just not, non-existent. And because of that, their line is backed up for months, as much as 6 months, some of these states, 9 months. So what that means for us is even though with, say the SEC comes back next week, boom, ADPI Capital, you're qualified. And then from there, 46 of those states, it's instant filings. It's like overnight, you're good. But in those 4 states, we have to independently file. And some take as little as 3 months, some take up to 9 months before we can raise money from people in those states. Now, the way it works is it's where the people are when they send you the money. So like, that's how you have to do it. It's not like where their tax status is. And that's probably an issue, more to us because our audience is military, right? So there's a lot of, we're all over the place. So that's kind of.
What's the name of the fund? Because I know Cornelius was asking about an example. And these are all public documents. So if you go on Edgar, 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 and you can then search for, you can probably just put any like sort of Reg A if you want to see a random one. But if you want to share the name of your fund, then anybody.
So I think the legal name on Edgar is ADPI Capital Fund 1, but our DBA is Equity Fund 1. And on Edgar,
if you Google ADP, if that's got it on, then if you just go to edgar.com and or just Google Edgar, ADP Capital, then that'll show up Cornelius, so you can kind of see an example of what an S1.
Yeah, here it is. Yeah, it's ADPI Fund 1 LLC. That's perfect. The Edgar thing, and it's on there. We filed on April 29th. So we filed on April 29th, and that's when officially Test the Waters started. And we're still going back and forth, and it's 2 months later. So.
So how long has it been so far then since you let's do it this way. I mean, forget about when because that's 6 months typically is when you actually file with the SEC, but you first got to hire your attorney. And
So we started this, October. So October was our first meeting with our attorneys. So, and we kind of really hit the ground running in like January. Right. So, I would say, I would call it like after the holidays is kind of really when we, screwed our head on straight. Right. But that's still, that adds 4 or 5 months to process. Yeah. So Yeah,
and
it's
you're not even there yet.
yeah. It's a process. Excuse me.
We should definitely have you and Eric back on, once that thing goes through and you start actually raising capital, and then you can kind of see. I'd be interested to see how long it ultimately took from basically the time you made the decision to do one and hire an attorney to the time that you were able to actually start taking in money. So
you nailed it, Mauricio. It's definitely not for everybody, but for our military community, which is Kevin, I'm going to correct you. It's 57,200 members.
Forgive me.
So we had the platform, but what military members traditionally don't have is the non-accredited, military and veterans. And speaking as a veteran, not accredited and don't have $50,000 to invest in your syndication. So what we do is break down those barriers for education and resources. And this was the logical next step based on what our humongous community was constantly asking for, is how do we invest with you guys? So
yeah, and that's why that's why it works. And again, the best example, and now I've got you guys, but Grant Cardone, is that he's got such a huge following that he's literally taking $5,000, $2,000 investments, which that's another thing you want to talk about. I mean, I know Eric and Kevin, this is it's almost like a passion project in addition to just sort of investment, but some people don't want to deal with $1,000 investors, right? I mean, that's you're going to be dealing with hundreds, and if
you don't want 1,000 K1s to process?
Yeah, all those K1s. I mean, the cost of doing those, but I know you guys have your mission behind it too. So
yeah, and we've set the threshold at $500 too.
Wow.
So yeah.
So literally somebody with $500 can, that's awesome.
Yeah, we really enjoy pain and paperwork. But since I'll say I'm in the system now since April 29th, when we announced we have 1.9 million in soft commitments registered.
Yeah.
And to you or I, syndicator, you syndicators on here, that's not a very big raise at all, but think of doing that $500 at a time.
Right.
That's the power of you need a platform to talk to in order to do something like this, for sure.
Awesome. Well, I really, really appreciate you guys sharing your story, because again, I can always look at it from the sort of the legal side, the technical side, all that kind of boring stuff, but I don't always get to even listen to the other side of what the experience is from the client's perspective. So thanks for sharing that. I really, really appreciate it. And it sounds like we got a couple of people from Wisconsin too, so I apologize if I disparaged your great state. That's a lot of issues with Reg D notices in Wisconsin. So anyway, anybody got a question for specifically on Reg A, or if you guys have a question for either Eric or Kevin, please, let's take advantage of them being here. But any specific questions on Reg A, and if not, we can always then open it up to. I've got a couple questions here that were pre-submitted, but I'm happy to open it up to Q&A in general.
Justin hit the nail on the head.
Yeah, we lost Eric there. Eric, we lost you. We got you on mute there for some reason.
No, am I good?
No, now we're good. Yep.
Sorry. Trigger finger. So Justin hit the nail on the head with taxes. It's definitely, as the more sophisticated investor you get, the more deals you get, you kind of realize that filing an extension April 15th is not much of a possibility for most of us anyway.
Right.
So for, part of the education on something like this for newer investors is notifying them, hey, not likely to get your K1 on time, and just giving them that buffer, that expectation that, hey, just have your CPA file an extension. If you don't have a CPA, we have a resource for you. Go to them, talk to them. You probably need to file an extension. So great point, Justin.
Adam, I know you said you joined late. What was the cost for all the filing docs? I mean, it depends. The number I would throw out, probably about 75 grand, kind of to ballpark. And then that doesn't include sort of the ongoing, once you get this thing done.
It's a bargain, man. 75 grand, it's a bargain. Double
and
that.
Then all that compliance, all the compliance nonsense after that, all your reports and your, entry, exit, not quarterly, semi-annual, and audited financials and all that stuff. So there's sort of an ongoing thing which you usually don't have in a Reg A. In a Reg D. Hunter, I know that you got your hand up, buddy. You want to unmute yourself there and ask a question?
Yeah. So first one's basic. I got two questions. So you presume you need to do filing for each property. Each Reg A property you do, and then the second question is, can you do multiple at a time? Because, I know you said it takes, anywhere between 6 to 9 months. So if, you're trying to, not wait 6 months for every property? You know, are you able to do multiple Reg A filings?
You can theoretically. Now, I don't know too many people, or if I know anybody who's actually done Reg A's on specific properties, because again, generally when you have a property in a contract, you've got to close within a certain amount. Now, theoretically, I guess you could be syndicating your own deal or something, and so there's no rush. So theoretically, you could do it on a specific property, but unless the number's high, again, with the cost of, if you're going to spend 75, maybe more on legal fees, it doesn't make a ton of sense to be doing it on a smaller raise. And so most people that I know that are doing the Reg A's are doing funds, but there's nothing that would prevent you from doing multiple funds at a time. Or I guess if you're going to do it for a particular property, you can certainly do it multiple at the same time, as long as you're complying fully with each deal, and that you're not skipping, you're not somehow advertising for a deal that hasn't been approved by the SEC yet. You've got to make sure that you've got that proverbial Chinese wall with all those deals, but you can certainly do concurrent raises.
Okay. All right. Thank you.
Yeah, of course. Thanks. Hunter. Let me see what else we got here. You're helping our vets. Yeah, thank you for helping our vets. You guys just did like a huge, Eric, you both of you, or is it just Eric? You guys just did a huge fundraiser and
that's Eric all the way.
10,000 miles or something. You guys did like a relay.
We hiked 170 miles, 28,000 feet of vertical climb in 9 days around Lake Tahoe. We raised $187,000 for Veterans Community Project.
That's awesome. That's awesome. Tracy, you had a question about how can foreigners invest in the fund? Foreigners can invest. One thing I didn't mention, actually, just kind of a minor thing maybe for most of us, but Reg A's are only available for US and Canadian companies. So if you're, if you're a foreign company, that's not US and Canadian, you wouldn't be able to do a Reg A. But if you're a foreign investor, there's really no reason why you couldn't invest just like you would with a Reg D. You got all the compliance nonsense and all the stuff you got to worry about, but that's something that would just be very similar to that. Is Pace? Are you really in the house, my friend?
I am here, and I love freaking seeing you, brother. You're the
hey, how you doing,
best.
My friend? How's it going, man?
Really good, man.
Good to see you.
You're one of my favorite people, by the way. I was texting Brandon Turner today talking about this live because I was talking to him about doing a fund-to-fund model into one of his deals. Yeah. And I go, hey, I've got 900 non-accredited investors ready to do a deal. Right. These are people I've known because of my mentorship. I'm so intimately involved in everybody's lives. And so I'm following Bethany's structure of how to continue to establish that pre-existing relationship. I'm following Mauricio's rules. And so my question is there a spreadsheet, a checklist, or something that you guys have that I can follow to get those 900 people to invest, let's say $5,000 each into a fund-to-fund model into Brandon Turner, who may not have a fund that allows non-accredited investors? Is that possible?
So you're talking about the checklist to get them through the process of, getting your students or people you don't necessarily know to establishing that substantive relationship, or are we talking?
Oh, I got that.
Got that part.
I'm currently working on that now, but is there a checklist of how do I get them into my fund of funds and roll them into a fund like a Brandon Turner fund that may or may not, or does not? Let's specifically say he cannot accept non-accredited investors.
Right. The challenge is that Brandon does, at least up until now, we've been doing 506C deals, right? So all of his offerings are 506C, which means that he can only accept accredited investors only, right? And so if you're going to do a Reg A or any deal at your level, your fund of funds, and you have even one non-accredited investor, then that LLC is no longer, for purposes of whether they're accredited or not, that's a non-accredited investor, and so would be not eligible to invest in Brandon's deal, unless the only way around that really is that if that's, which it wouldn't be the case in your case.
I love it when you say the word unless, by the way. That's great. It gives me an opportunity. What's the unless?
It's like, was that Dumb and Dumber? So you're telling me there's a chance. It really isn't a chance. I'm just telling you, unless the company's already been in the, has $5 million in assets that wasn't raised for the specific purpose of the investment. So for example, the classic example would be that if you're, a doctor's office and there's a group of doctors and you already have a practice and you've got a medical building and you've got assets already at 5 million, then even though theoretically, if one of those doctors was non-accredited for whatever reason, then the entity is accredited because it's got $5 million in assets. That
Is
wasn't
$5
set up.
million a very specific number, or is that an example you're throwing?
No,
out?
that's a very specific example. Under the definition of an accredited investor, it's an LLC or an entity that has $5 million in assets that was not obtained for the purpose of specifically investing in the deal. So for example,
Interesting.
I have an LLC, I can't go raise it $5 million into an LLC and then say, well, now I've got, now there's an argument to be made that if you're doing a fund, and that's something I'm actually doing a little bit more of a deep dive because it's a little bit of a nuance thing. But the question becomes, if you're doing a fund, so you're not raising, so for example, you're doing a blind fund. So you're not raising money specifically for, if you use Brandon Turner's example, for Brandon's deal, but you're going to be raising money for multiple deals, for Brandon and Kevin and Mauricio and Bethany and whoever. Then did you really, and let's say you raise $10 million and now you've got a company that has $10 million in assets. The question becomes, was that $10 million raised for the specific purpose of investing in Brandon Turner's deal? There's an argument to be said that it's no, but we're actually in the process of digging into that deeper because that's something we encourage, not encourage. We actually won't do a deal usually where somebody's raising money that's just going into one deal. So we're always encouraging people to do blind funds anyway. So you're not actually specifically, in your example, you wouldn't specifically be talking about Brandon Turner's deal. You're saying, hey, I'm going to go raise $50 million and I'm going to go find operators that I vetted, that I like, that maybe you come up with asset classes. And then Brandon's will just be one of many deals that you're looking at. And you're going to make a decision whether to invest in Brandon's deal, but you're not actually selling Brandon's deal. But anyway, so that's something we're looking into. But in your specific example, I didn't mean to get you off the thing. If you're doing a Reg A and you have non-accredited investors, your LLC is non-accredited for purposes of that. And so you wouldn't.
Well, what if I have $5 million or more in assets
that were not obtained, that were not raised, that were for the specific purposes of doing a syndication? Then that's right. So for example, if you wanted to take for example, let's say you had a company, I know you have a company, but Pace's company, not the syndication company, but your current company, maybe some of the shareholders are not accredited. But if you've got more than $5 million in assets because you own some buildings or you have, however you measure your assets, and you have $7 million in assets, then your company would be accredited, even though you have a couple of non-accredited.
Would I have to deed those assets over to that LLC that's raising the capital?
No, the company that's raising the capital would just, the company that's raising the money for the capital would not be considered accredited. Now, I think what you were asking me is, can you kind of get around that by deeding assets? And now I've got assets. You're really getting
LLC that equate to $5 million and then allow me to go raise money, and that LLC is now an accredited investor.
To me, that sounds like a fraudulent transfer page.
Damn it!
Unless
I was going to say.
Unless. No, so these are all great questions. But yeah, Kevin, I know you wanted to say something about the the non-accredited thing.
Well, no, currently dying of a coughing fit if I can get over this, but yeah, I went through that rabbit hole with our attorney, and the fund of funds model she shot down pretty quickly because she said for a real estate fund and a Reg A, we have to own 51% of the real estate in the fund, which I didn't know of beforehand, but because the fund of funds is kind of like a buzzword these days. But she said if you're investing and like your fund wants to be an LP in another fund, everyone has to be accredited. And to do a Reg A, we would have to keep 51%. Excuse me.
Yeah.
But yeah, Pace, I'll hit you up, man.
Yeah, thank you. I appreciate you, brother. That's super value driven for you to DM me as well on Zoom. I appreciate that. Okay, I have another question then, Mauricio, if you don't mind.
Yeah, go ahead.
If you guys don't mind me monopolizing another 7 minutes.
I don't see any questions in the chat, although if you've got questions, pop in the chat or raise your hand and we'll get to you. But go ahead, Pace.
Okay, so similar but a little bit separate. I've got this guy that comes to me. He buys a car wash on seller finance, right? So there's an underlying note with the seller. Car wash out of New Jersey. I don't know that that's going to matter, but maybe it does. And he says, "Hey, I need to give the seller $40,000, and then it's going to cost me another $100,000 to get this thing up and operational. I don't want to raise money. I want to bring in partners." If he goes and brings in $140,000 of partners, people that contribute to that LLC and become owners of that LLC, is that technically raising capital, or is that just forming a partnership?
It depends on what they're doing. So if they are actively participating in the operations and running and decision-making of that car wash, then that's just what we would call a joint venture. You just basically have a business and you've got a bunch of partners, but they all have to be contributing some level of expertise, and they're going to be rolling up this. Like you said, you're starting a business or you're starting a partnership with 3 or 4 people. If somebody's just coming in and writing a $50,000 check and that's all they're doing, and then they're going home and just collecting the royalties or whatever from the car wash, that's going to be a passive investor. But if they're active, that's the key. That's what differentiates a securities offering from a joint venture is the level of activity that each partner, because again, you're not raising money, you're just starting a business between me and Pace, you, me, and 3 other people. We're contributing some money for sure. We're all contributing money, but we're also all rolling up our sleeves and contributing to the returns, because as you remember, the definition of a security is that the returns are being generated by somebody's effort, right? Your efforts, Pace, or my efforts. And so the way around that is to make sure that the returns are generated by everyone's efforts. And so as long as you have, 4 or 5 people, not more than 4 or 5, the SEC gets a little bit squeamish after 5, and they'll argue that it's really difficult for all 5. If you have 8 people in there or 10 people, are they really all actively involved in carrying their weight, or is somebody just really writing a check and going home? But in your example, there's a way, if they're again doing something, they have some level of expertise in the car wash, and they're doing some kind of a work, and you bring them in as partners, legitimate partners, and that's a joint venture, not a securities offering.
And I'm sure that's where you would agree also, Mauricio, that that's where you need a very granular MOU right off the bat as soon as possible, right? If you're gonna go with JV versus syndication, make sure it's crystal clear to everybody. And
you want to make sure that either the MOU or in the partnership agreement or the LLC agreement that you outline. But it's more than just outlining. I mean, yes, that's a good step, but at the end of the day, the SEC always looks past all these. I mean, you want to have the agreement as your base, but at the end of the day, if something were to become an issue, and it has become an issue, and it usually becomes an issue, Pace, when your car wash goes belly up, and the one investor who really didn't do much and was, just wrote you a check and just lost 50 grand. Well, they're going to go talk to their attorney, and they're going to say, well, this really was a securities offering. It wasn't joint venture, and you didn't follow the paperwork. You didn't follow the securities rules. And so my remedy is you've got to give me my money back, even though we lost the money. So it's what you're doing. They're going to literally, I always joke a little bit. It's not really that you're doing an audit in front of an auditor across the table from you, but essentially they're going to be asking you those questions like, okay, Pace, I see that Eric here is part of your team. He owns X percent, put in a little bit of money. What did he do in this car wash business? And you better be able to show that Eric did something, whether he was participating in every meeting, he was on the board. Again, if the less amount of people, the easier. Like if you've got 3 or 4 people, I would just make everybody a co-manager, right? And now you've got 4 co-managers, and every decision needs to be signed off by all 4 of you. That's probably something you can document pretty easily, because every time there's a major decision, you're going to write some resolution. Everybody's going to agree to refinance or add or hire or whatever decision making. But it's going to be your burden to prove that these folks did something and were actively involved in the business, as opposed to just write you a check and go home and have you do all the work and give them a return, because that's a security.
I'll wash cars for you, Pace.
All right, bro. I need 100 grand though.
I warn you, I wear short shorts though when I wash.
Oh, perfect.
Cars.
That's a requirement.
Okay.
The name of the car wash is called Shorties. So you're good.
Love it.
Hey, Tracy, I do want to address, I know we talked about the Canadian thing, and then you said you were Canadian. The only issue on the Canadians, Tracy, is that you just got to be careful about the taxes. Canadians don't recognize LLCs, and so they generally default to corporations for tax purposes. And so Canadians typically get double tax. So it's just really important for you, if you're making an investment into Pace's car wash business or into Kevin or Eric's a fund, that you just make sure you're talking to your CPA in Canada, make sure that the structure that Eric's using, that Pace is using, whoever, isn't going to have any adverse tax consequences. Because the last thing you want to have is, make an investment and get taxed, basically a double tax issue, and you're not going to be happy with that. So just keep that in mind. Sorry, Pace, I didn't mean to cut you off. I just saw that question. I was kind of a lingering one from before you came on. So.
Bro, you've given me so much attention. As always, you're the best.
No, I appreciate it, buddy. Always. I'm bummed I missed you at Limitless. I saw that you were I think you came in right after I was only there day 1. I think you came in day 2.
You were the one person I wanted to come in and give a hug to, man.
Appreciate that. Although I got COVID right after that. So Anyway, I know Kevin bounced. Tracy, anybody else got any questions? Just maybe just unmute yourself and just ask it on any topic. If not, we will call it a day. Always appreciate you guys stopping by on Wednesday, and just always enjoy doing these. And if you've got any particular topics you want to cover, head over to the Facebook group. It's mauriciorauld.com/FB group, and just post a topic you want us to cover, and we'll either bring in a guest if it's a non-legal issue, or we'll just address it. But until then, we'll see you on the Facebook group. Thanks, everyone.